Welcome back to another deep dive into our sources. Usually when we think about the rules of a game, there is this very clear, impenetrable line between the referee and the players.
Right.
I mean, the referee wears the stripes, they blow the whistle, they enforce the boundaries, but they never touch the ball.
Yeah, their entire existence in that context, it relies on neutrality. If they start passing the ball, the integrity of the whole game just collapses.
Exactly. And stepping into the world of constitutional law, we already know the baseline rule for how states interact with the national economy.
Rare.
We covered this in the previous deep dive materials. The Constitution basically acts as that referee. And the Dormant Commerce Clause is the whistle. We all know the basic premise, right? A state cannot discriminate against out-of-state commerce. If a state tries to rig the private market to favor its own home team, well, the referee blows the whistle, then the law gets struck down.
That's the foundational principle of a unified national market. I mean, we cannot have 50 separate economic fortresses.
Okay, so let's unpack this, because today the sources are throwing us an absolute structural curveball. What happens when the referee takes off the striped shirt, puts on a team jersey, and actively starts running the ball down the field?
Oh, yeah.
Like, what happens when a state isn't acting as a regulator, but as a literal player in the private market?
Well, then we enter the market participant exception. And the core shift here is that the Constitution's deep suspicion of state power, it just suddenly evaporates.
Wow, really?
Yeah.
Yeah.
When a state is using its sovereign power to tell private businesses what to do, the courts are incredibly strict. But when a state is simply deciding how to spend its own money or distribute its own property or run its own operations, the rules completely change.
So wait, if a state enters the market as a buyer or a seller or an employer, those standard rules against discrimination, the red cards we expect from the referee, they just vanish.
They largely do, yeah. When the state is participating in the market rather than regulating it, they are actually allowed to play favorites. They can legally prioritize their own local residents over out-of-state competitors.
Okay, here's where it gets really interesting for you listening. Think about a massive infrastructure boom where there is a sudden, a crippling shortage of building materials across the country.
Right, a massive supply chain issue.
Yeah. And a state happens to own a massive cement plant and a gravel quarry. Under normal regulatory rules, a state couldn't pass a law saying private cement plants can only sell to locals.
No, absolutely not. That's classic discrimination.
But because the state owns this specific plant, they can shut their doors to out-of-state buyers and say, we are selling our cement exclusively to in-state construction companies first.
And you have to look at the underlying mechanics of why the courts allow that. The state isn't interfering with the private flow of goods, It is distributing a resource that was funded and maintained by its own taxpayers. Forcing a state-owned facility to sell its scarce resources to outsiders would essentially mean forcing local taxpayers to subsidize the economic development of neighboring states.
That makes a lot of sense when you frame it around taxpayer funding. It's like playing a board game. It's the difference between the person who wrote the rule book changing the rules mid-game to help their friends versus
a player just choosing to trade their own sheep exclusively for local wood.
Exactly. You can be as biased as you want with your own sheep.
That is the exact mechanism at play. Consider a city building a new public library. They are using city tax revenue. Because the city is acting as a purchaser of labor in the market, they can legally mandate that 50% of the construction workers hired for that specific project must be local residents.
Which has massive ripple effects. A contractor wins that bid, and suddenly they might have to lay off out-of-state workers or hire new local ones just to comply.
Yeah, they do.
So the local labor market shifts entirely because the city played its hand.
It does shift the market, but crucially, it only shifts the market for that specific transaction. The city isn't passing a sweeping law that affects how private money is spent.
Right, but how do we actually define what market the state is participating in? Because, a state government is a massive apparatus.
Oh, it's huge.
They buy office supplies, they hire thousands of people, they run vehicle fleets. It feels like they could claim to be a participant in almost any industry to justify protectionist policies.
Well, this raises an important question. It is not a blank check. The state has to be functioning essentially like a private business within a highly specific, definable sphere. You have to isolate the exact transaction.
Look, zooming in on the specific receipt.
Exactly. Is the state acting as a purchaser of labor, a seller of goods, a buyer of medical supplies? You have to define the exact market.
And for you listening, this isn't just theoretical. If your local government decides to build a new bridge tomorrow, this exact loophole is what allows them to legally refuse to hire anyone who lives across the state line. But if that same local government tried to pass a zoning law mandating that a private developer building a commercial skyscraper downtown must hire local workers, they get struck down immediately.
Precisely. In the bridge scenario, the city is a player spending its own money to buy labor. In the private skyscraper scenario, the city is trying to act as a referee, altering the rule book for private actors spending private money.
Okay, so the state's power as a player is strictly limited to its own immediate transactions. But if a state can favor locals when they are taking their turn in the game, does that logic extend further?
What do you mean?
Like, can they force the people they do business with to keep favoring locals even after the state's turn is technically over?
Now we're looking at the most heavily contested boundary of this entire concept. This is downstream regulation, and the short answer is no.
Okay, let's look at the classic timber scenario from the sources. A state owns vast tracts of forest. They harvest the timber. Selling that raw timber to in-state buyers first is perfectly legal.
Right.
They are a market participant, selling their own property.
Correct. That is the immediate transaction.
But let's say the state adds a requirement to the sales contract. They tell the buyers, we will sell you this discounted timber, but you are legally obligated to process all of it at in-state sawmills before you can resell it or ship it across state lines.
Yeah.
The moment they add that condition, the exception disappears. They are hit with a constitutional violation.
Completely. The state loses its protection.
Wait, I have to push back on this.
Yeah.
If it's the state's timber to begin with and they have the power to just not sell it at all, why can't they dictate how it's used? Private sellers do this constantly.
That's a fair point. They do.
Right, like if I sell someone a fast food franchise, my contract dictates exactly where they buy their ingredients, what their signs look like, and how they run their business indefinitely. How come a state loses its player status just for adding a standard contract clause?
What's fascinating here is the structural limit of sovereign power. Yes, private entities use contracts to control downstream behavior all the time, but a state has the coercive weight of the law behind it.
Okay, I see.
In this scenario, the state is a market participant in the timber sales market. But the timber processing market, the sawmills, that's an entirely separate secondary private market.
So they're leveraging their power in Market A to artificially manipulate Market B.
Exactly. Think about the economic mechanism of what's happening to the out-of-state sawmills. Those out-of-state processors might be faster, they might be cheaper, and more efficient.
So they can't get the wood.
Right. They are suddenly starved of raw materials and forced to lay off workers, not because they are losing in the free market, but because a neighboring sovereign entity leveraged its monopoly on raw timber to create a captive market for its own local processors.
Wow, it artificially suffocates out-of-state businesses. It's basically coercive regulation disguised as a sales contract.
Right. The state is reaching beyond its own immediate transaction to dictate downstream business arrangements. The moment it does that, it ceases to be a participant making a choice and reverts to being a regulator coercing a market.
There's another scenario in the sources that illustrates this perfectly with natural gas. Imagine a state-owned energy company selling discounted natural gas to in-state residents.
Okay.
That initial sale is fine, but the state prohibits those buyers from turning around and reselling that gas to people out of state.
Which is another classic downstream violation.
But practically speaking, how do they even track what I do with natural gas after I buy it? It seems impossible to enforce a resale ban without setting up an entire regulatory apparatus.
And that enforcement is the regulation. To ensure buyers aren't reselling the gas, the state has to monitor private secondary transactions, penalize violators, and track the flow of goods after the initial sale has completely cleared.
Oh, wow.
Yeah, they're no longer just a seller, they're policing a secondary market.
Okay, so the state's player status has a hard expiration date. It ends the exact moment the transaction clears. No strings attached to the secondary market.
That is the crucial boundary. You cannot use your status as a player to sneakily rewrite the rules for the rest of the game.
So if the state can't control downstream physical goods like timber or gas, what happens when there is no physical product at all?
Like money.
Yeah, what if the state skips the goods entirely and just starts handing out cold, hard cash to local businesses?
Now we have to follow the money into the subsidy spectrum. This requires distinguishing between direct government spending and coercive taxation and the economic mechanisms of both.
Let's start with direct spending. A state takes money from its general tax fund and offers cash grants to local tech startups, or pays a bounty to anyone who delivers scrap metal to an in-state recycling center. This is generally treated exactly like market participation.
Because the state is functioning as an economic actor, injecting its own resources into the market to encourage specific activity, direct spending from the general fund is a shared burden. All state taxpayers chip in to benefit a specific local industry.
Right.
It is a purely internal political choice. And the Constitution gives states incredibly wide latitude to spend their own general treasury funds to help their own citizens.
But then we get to the vulnerable trap, the tax and subsidy combination. Let's trace the dollar on the dairy scenario, because this is where a state tries to get incredibly sneaky.
Oh, the dairy hypo. This is a classic.
A state wants to prop up its struggling local dairy farmers. They can't just ban out-of-state milk, so they impose a special tax on all dairy products imported from other states.
Which fundamentally is a discriminatory tariff. It artificially raises the price of out-of-state goods.
Right. An out-of-state gallon of milk now costs 50 cents more on the grocery store shelf. The consumer pays that penalty. But then the state takes that exact tax revenue generated by the outsiders and immediately hands it out as a cash subsidy exclusively to the in-state dairy farmers.
It's so blatant.
Yeah, this allows the local farmers to lower their prices by 50 cents. It's a double whammy that totally distorts the market price.
And the courts strike this down immediately.
But wait, if giving out cash subsidies is perfectly legal, as we just established with the scrap metal bounties, why does this specific setup fail so spectacularly?
Because of how the money is generated. If we connect this to the bigger picture, it's not just a subsidy. It's a weaponized penalty. Think of it less like an internal gift and more like a casino where the house charges a heavy cover fee exclusively to people from out of town.
Oh, I see where this is going.
And then takes that door money and hands it out as free chips to the locals.
That's a brilliant way to look at it. It's basically a protectionist Robin Hood scenario. They are specifically taxing the outsiders to fund the insiders.
Exactly. The state is artificially burdening interstate commerce to fund a competitive advantage for its own residents. It ceases to be market participation and becomes a coercive protectionist scheme.
And this same economic mechanism applies to certain tax credits, right?
Yeah.
Imagine a state says, we will give a massive tax break, but only to manufacturers who can prove they use at least 80% in-state raw materials.
Right. It sounds like a benefit of credit. But look at the mechanism. If a manufacturer uses out-of-state suppliers, their taxes go up relative to their competitors. It operates exactly like a discriminatory tariff, financially penalizing any reliance on the interstate market. It forces businesses to sever their out-of-state supply chains just to remain competitive.
So giving a gift out of your own general wallet is fine. But weaponizing an incoming penalty against outsiders to fund an internal advantage is where the courts draw the line.
Precisely. How the money moves is everything.
Okay, so we know how the state spends its money matters. But as we dig deeper into the sources, we find that who the state favors matters just as much. The identity of the beneficiary can completely flip the legal outcome.
Yes, we have to distinguish between a state favoring a public entity versus a state favoring a private local business.
Let's ground this in the real world with waste disposal. A county passes a local law requiring every single garbage truck, every private waste hauler operating in the county to deliver all of their trash to one specific processing facility. They're legally barred from taking it across the state line to a cheaper dump.
They're essentially creating a local monopoly for waste processing.
Right. Now, scenario A. That specific processing facility is owned and operated by the county itself. It is a public entity.
Yeah.
The courts are actually quite lenient here. They generally allow this forced monopoly.
They do, yeah.
But scenario B. The exact same county passes the exact same law, but the required processing facility is a privately owned local company. The courts look at this and say it's standard discrimination, completely invalid.
Night and day difference in the outcome.
So what does this all mean? Is the government just allowed to create a monopoly as long as they're the ones wearing the monopoly top hat? Like, how does forcing everyone to use a county facility not violate the rules against rigging the market?
Well, it goes back to the core philosophy of what a government actually is. If we connect this to the bigger picture, waste disposal, much like water treatment or basic utilities, is recognized as a traditional government function.
Yeah, okay.
It is a structural, historical obligation of the local government to ensure public health, sanitation, and safety.
So when they force the garbage trucks to go to the county facility, they aren't doing it to enrich a private buddy.
Exactly. They aren't steering profits into the pockets of local private business owners at the expense of out-of-state competitors. They are utilizing their regulatory power to structurally perform their own public service obligations.
That makes sense.
The courts view a government funneling resources to maintain its own vital public infrastructure fundamentally differently than a government rigging the free market for local private profit.
Okay, the monopoly top hat is allowed, but only if it's worn to provide a traditional public service. That distinction makes the economic reality much clearer.
It prevents the state from using public health as an excuse to engage in economic protectionism for private companies.
All right, we have covered some incredibly dense ground here. We've looked at the state as a player, the severe limits on downstream control, the casino economics of tax and subsidy traps, and the leeway granted for traditional government functions.
It's a lot to keep track of.
It really is. So let's actually walk through how someone would apply this if they were trying to figure out if a local law was constitutional. I want to build a mental checklist for you listening.
There is a really logical 5-step workflow for analyzing any of these situations in the wild.
Let's do a rapid-fire classification. First thing you always look for, did Congress authorize it?
Right, because Congress holds the ultimate federal power over interstate commerce. If Congress passes a law expressly permitting states to favor their own locals in a specific industry, the entire constitutional issue drops away. The referee has essentially given explicit permission for the play.
Okay, assuming Congress is silent, we move to step 2. Is the state regulating or participating? Let's reason through a scenario. Say a state-owned public hospital decides it will only buy its surgical supplies from in-state medical distributors.
In that case, we are clearly looking at participation. The state is acting as a buyer for its own facility, spending its own funds. They are perfectly allowed to favor local suppliers.
But if the state passes a law forcing all private hospitals in the state to buy from those same local distributors,
that shifts instantly to regulation. The state is using sovereign power to dictate private spending. That triggers the strict constitutional review.
which brings us to step 3. Let's say they are participating like selling timber. We have to ask, are they staying within their own market transaction, or are they adding downstream conditions?
You're right. If they just sell the wood, they are safe. If they force the buyer to use local mills later, they lose the exception entirely because they are regulating a secondary market.
Step 4 deals with what happens if they are regulating. We revert to the baseline rule. Is the regulation blatantly discriminatory against outsiders, or is it even-handed?
If it's discriminatory, it almost certainly gets struck down. If it's even-handed but still impacts commerce, the courts will weigh the local benefits against the burden on the national market.
And finally, step 5. We look for special factors. Is this a tax and subsidy trap, or are we dealing with a traditional government function?
Exactly.
Let's talk through one last scenario to put it all together. A state generates electricity from a massive state-owned power plant. They sell that electricity to their own residents at a significantly lower rate than they charge to the neighboring states on the grid.
Okay, let's apply the workflow. Congress hasn't spoken. Is the state regulating private power companies? No, they're selling their own product from their own public facility.
Okay, so step 2, they are participating.
Right. Step 3, are they controlling what people do with the electricity downstream? No.
They're simply prioritizing their own residents with a resource built by their own taxpayers. So it's perfectly constitutional.
It is. And understanding these steps isn't just an academic exercise. These are the invisible lines of power that dictate the architecture of our entire domestic market.
They dictate where the goods on your grocery shelves come from. They determine who gets hired to build the new highway interchange in your town. They limit exactly how your state politicians are legally allowed to spend your tax dollars to boost the local economy.
It is the machinery operating just beneath the surface of local news.
Let's recap the major aha moments we've hit today. We started with the realization that the state isn't permanently stuck being a referee. When the state uses its own money, property, or operations, it steps onto the field as a player and can absolutely play favorites.
But that power is strictly contained. They cannot leverage their transaction to aggressively suffocate out-of-state competitors in downstream secondary markets.
Right. We also saw that while direct government spending is fine, weaponizing the tax code, charging outsiders a cover fee to hand out free chips to insiders is an illegal trap.
And finally, the courts will give local governments far more leeway to monopolize a market if they are performing a traditional government function, like waste disposal, rather than steering profits toward private local companies.
You now have a completely new lens for reading municipal politics. When you see a headline about a new city construction mandate or a massive state grant program or a dispute over local utilities, you aren't just reading the political spin anymore.
No, you know the exact economic mechanisms at play.
Right. You know when the referee has stepped onto the field.
It fundamentally changes how you view the limits of government power.
It really does. And I want to leave you with one final lingering thought. Something to mull over that builds on that last point about traditional government functions. We know that things like water treatment and trash disposal get special leeway because they are historical, fundamental public services necessary for a community to survive.
Correct. They are deeply rooted in the history of municipal obligations.
So this raises an incredibly important question for the future. What happens as technology evolves? The definition of a fundamental public service is not frozen in time. What if, 5 years from now, a major city decides that high-speed municipal broadband is no longer a luxury, but a basic structural necessity for participating in the modern economy?
Oh, or consider massive municipal green energy storage grids, which are becoming vital for local resilience.
Exactly. If a state builds out a massive public broadband network and tries to legally force local reliance on it to the detriment of out-of-state private tech giants, what happens? Will the courts expand this traditional government function exception to protect the state, agreeing that internet access is the new water treatment?
That's the big question.
Or will the private tech companies successfully argue that the state has gone too far and is simply using a legal loophole to illegally rig a highly lucrative, modern private market?
It is arguably the next great frontier of constitutional litigation. As technology shifts, where does the traditional government obligation end and the modern private market begin?
The referee is eyeing the ball, and the tech companies are eyeing the referee. We want to thank you for joining us on this deep dive into the sources. Keep questioning the economic structures around you. Keep looking for those invisible lines of power, and we will catch you next time.